Sarah remarried at age 58. She had 2 adult children from her first marriage, and her new husband had 3. They were deeply in love and wanted to build a life together. Sarah updated her will to leave everything to her new husband, thinking he would take care of her children after she was gone. When Sarah died at 68, her husband inherited her entire estate worth $1.2 million. Within 6 months, he updated his will to leave everything to his 3 children. Sarah's 2 children received nothing, not $1 from their mother's lifetime of savings. This is not a rare story. It happens thousands of times every year in the United States, Canada, the United Kingdom, and Australia. Adult children are accidentally disinherited because their parent remarried and didn't update their estate plan properly. But here's the tragic part. Sarah wanted her children to inherit. She just didn't know that a simple will wouldn't protect them in a second marriage. She needed a different type of estate planning structure, and no one told her. If you're remarried, planning to remarry, or even considering it, this video could be worth hundreds of thousands or even millions of dollars to your family. Over the next 50 minutes, I'm going to show you exactly how to protect both your new spouse and your children from previous relationships. You'll learn why your old estate plan is probably invalid or dangerous after remarriage. I'll explain the specific types of trusts designed for blended families, like QTIP trusts and bypass trusts. We'll cover beneficiary designations on retirement accounts and life insurance, which often override your will and cause massive problems. This guide specifically addresses estate planning laws in the United States, United Kingdom, Canada, and Australia. While the principles are similar, there are important differences I'll point out as we go. Before we start, critical disclaimer, I am not an attorney. This is educational content only. Estate planning laws vary by state, province, and country, and they change frequently. You absolutely must work with a licensed estate planning attorney in your jurisdiction. Think of this video as your informed starting point before meeting with professionals. I've included detailed timestamps below so you can jump to the sections most relevant to you. But I strongly recommend watching the entire masterclass because estate planning for second marriages is complex, and each piece connects to the others. If you're serious about protecting your family, subscribe to Midlife Money Method for more in-depth financial guidance. Now, let's dive into why second marriages create unique estate planning challenges. Chapter 1. The second marriage estate problem. Let's start by understanding why remarriage completely changes your estate planning needs. When you marry for the first time, estate planning is relatively straightforward. You typically want everything to go to your spouse and then to your children. Simple. In a first marriage with biological children together, everyone's interests are aligned. Your spouse wants to take care of your shared children because they're her children too. There's no conflict of interest. If you die first, your spouse inherits. When she dies, your children inherit. Everyone gets taken care of in the natural order. But second marriages with children from previous relationships create fundamental conflicts of interest. Let me show you why with a real scenario. John, age 62, remarries Linda, age 60. John has 2 adult children from his first marriage. Linda has 3 adult children from hers. John has accumulated $800,000 in assets. Linda has $400,000. Here's the core dilemma. John loves Linda and wants to make sure she's financially secure if he dies first. That's natural and appropriate. But John also wants his $800,000 to eventually go to his own 2 biological children, not to Linda's 3 children. If John uses a traditional will leaving everything to Linda, hoping she do the right thing and preserve his assets for his children, he's taking an enormous risk. Even if Linda has the best intentions today, several things could go wrong. Risk number 1. Linda might remarry after John dies. Her new husband could influence her to change her will, cutting out John's children entirely. Risk number 2. Linda's 3 biological children will naturally pressure her to give them their inheritance while she's still alive. John's children aren't her biological children, so she has less emotional attachment to them. Risk number 3. Linda might need long-term care in her later years, spending down all the assets John left her. His children get nothing, even though those assets came from their father. Risk number 4. If Linda doesn't update her will after inheriting from John, and she dies unexpectedly, her assets, including everything she inherited from John, go to her children automatically. John's children are not even mentioned. According to estate planning attorneys, approximately 60 to 70% of second marriages that use simple wills result in the first spouse's children receiving significantly less than intended, or nothing at all. Now, this problem exists in all our target countries: the United States, United Kingdom, Canada, and Australia, but the legal mechanisms to solve it differ slightly by jurisdiction. Throughout this video, I'll point out these differences. In the United States, the complexity increases based on whether you live in a community property state or a common law state. Community property states include California, Texas, Arizona, Nevada, New Mexico, Washington, Idaho, Wisconsin, and Louisiana. In these states, assets acquired during marriage are automatically owned 50-50 by both spouses, which affects estate planning significantly. In the United Kingdom, there's no forced heirship, meaning you can technically disinherit your children entirely. However, dependents can challenge your will under the Inheritance Provision for Family and Dependents Act of 1975. This includes both your current spouse and potentially children from previous marriages if they were financially dependent on you. Canada adds another layer of complexity because each province has its own estate laws. For example, Quebec operates under civil law rather than common law, making estate planning quite different. British Columbia, Alberta, and Ontario each have unique rules about spousal rights and dependent claims. Australia similarly varies by state and territory. New South Wales, Victoria, Queensland, and others each have slightly different approaches to family provision claims, which allow eligible people to challenge your will if they believe they haven't been adequately provided for. Here's what you need to understand. A simple will that says I leave everything to my spouse does not protect your children in a second marriage, regardless of which of these countries you live in. You need specialized estate planning structures designed specifically for blended families. You essentially have two competing goals that seem contradictory. Goal 1. Provide financial security for your new spouse during their lifetime. Goal 2. Ensure your own biological children inherit your assets after your spouse passes away. The question is, how do you accomplish both goals simultaneously? The answer involves specific types of trusts, careful beneficiary designations, and strategic use of life insurance. We're going to cover all of these in detail. But first, let's talk about why your existing estate plan, the one you created before you remarried, is probably invalid or dangerous right now. Chapter 2. Your old plan won't work anymore. If you created a will, trust, or any estate planning documents before your current marriage, I have important news. Those documents are likely either legally invalid now, or they're going to cause serious problems for your family. Here's why. In most jurisdictions across the United States, United Kingdom, Canada, and Australia, marriage automatically revokes any pre-existing will. This is a legal principle designed to protect new spouses from being accidentally left out of an estate. Let's say you created a will 15 years ago when you were married to your first spouse. That will left everything to your then wife and your children. You divorced, and 5 years later, you remarried. In most cases, the moment you remarried, your old will became invalid. Now, the specifics vary by location. In the United States, some states automatically revoke the entire will upon remarriage. Other states only revoke the portions related to your previous spouse, but leave the rest intact. A few states don't automatically revoke wills at all upon remarriage, but give your new spouse the right to claim a portion of your estate regardless of what your will says. In the United Kingdom, under the Wills Act of 1837, marriage automatically revokes any will made before the marriage unless the will was made in contemplation of marriage to that specific person. This means if you had a will before remarrying, it's almost certainly invalid now. In Canada, the rules vary by province. In Ontario, for example, marriage revokes a previous will unless the will specifically states it was made in contemplation of that particular marriage. British Columbia has similar rules. Quebec, operating under civil law, has slightly different mechanisms, but the outcome is similar. Your old will probably doesn't work anymore. Australia follows the common law principle across most states and territories. Marriage generally revokes a previous will unless that will explicitly states it was made in contemplation of the upcoming marriage to your current spouse. So what does this mean practically? If you remarry and didn't create a new will or trust after that marriage, you're likely dying intestate, without a valid will even if you think you have estate planning in place. When you die intestate, your estate is distributed according to your jurisdiction's intestacy laws, not according to your wishes. Let me show you how these intestacy laws typically work in second marriages and why they probably don't match what you actually want. In the United States, intestacy laws vary by state, but common patterns emerge. Typically, if you die with a surviving spouse and children from a previous relationship, your estate is split between your spouse and your children. The exact split varies. It might be 50-50, or 1/3 to your spouse and 2/3 to your children, or other formulas. Here's the problem. This means your new spouse doesn't inherit everything, which might leave her without enough to live on. And your children receive their inheritance immediately, which might be too soon if they're young adults not ready to manage money. Plus, there's potential for immediate conflict between your spouse and your children over asset division. In the United Kingdom, if you die intestate with a spouse and children, your spouse inherits your personal possessions plus the first £270,000 as of 2025 of your estate, plus half of anything above that amount. Your children split the other half. If your estate is worth £800,000, your spouse gets £270,000 plus £265,000, half of the remaining £530,000, totaling £535,000. Your children split £265,000. Canadian provinces each have their own intestacy formulas. In Ontario, if you have a spouse and children, your spouse receives a preferential share currently around $350,000 as of 2025 plus a portion of the remainder, with your children receiving the balance. The exact amounts and percentages vary by province. Australian states similarly have varying intestacy formulas, but generally follow a pattern of giving your spouse a significant portion or preferential share, with children from any relationship sharing the remainder. Why are these intestacy outcomes problematic for second marriages? For main reasons. Problem 1. Insufficient for spouse. First, your new spouse might not receive enough to maintain their lifestyle, especially if your estate is modest and must be split multiple ways. Problem 2. Too much too soon for children. Second, your adult children might receive large inheritances immediately without the protections of a trust that could shield assets from their creditors, divorcing spouses, or their own poor financial decisions. Problem 3. Forces immediate liquidation. Third, intestacy often forces the immediate sale of assets like a family home or business to divide proceeds, rather than allowing your spouse to continue living in the home or keeping a business intact. Problem 4. Creates family conflict. Fourth, and perhaps most damaging, intestacy creates immediate conflict between your spouse and children because they're essentially competing for a limited pool of assets. This conflict can destroy family relationships permanently. But here's what catches most people. Even if you created a new will after remarrying, you likely have a ticking time bomb in your estate plan that most people completely forget about. I'm talking about beneficiary designations. Your retirement accounts, 401k, IRA, pension all have beneficiary designation forms. Your life insurance policies have beneficiary forms. Some bank and brokerage accounts have payable on death or transfer on death designations. Here's the critical fact. Beneficiary designations override your will. It doesn't matter what your carefully crafted will says. If your beneficiary designations say something different, the beneficiary designation wins. Scenario: you divorced 10 years ago. Your ex-spouse was listed as beneficiary on your 401k worth $400,000. You remarried 5 years ago. You created a new will leaving everything to your new spouse, but you forgot to update the beneficiary form on your 401k. When you die, your 401k $400,000 goes directly to your ex-spouse, because that's what the beneficiary form says. Your will has zero control over this. Your new spouse is devastated. Your children are furious, and it's too late to fix. This exact scenario went to the United States Supreme Court in 2001 in the case Kennedy v. Plan Administrator. The court ruled that beneficiary designations control, even when they clearly conflict with the person's obvious intent. The ex-spouse kept the money. So before we discuss the solutions, the trusts and strategies that will protect everyone, you need to do something this week. Pull out every account statement you have, find the beneficiary designation forms, and check who's listed. We'll cover what to do with them in Chapter 5, but first, let's talk about how to protect your children's inheritance while still taking care of your spouse. Chapter 3. Protecting your children's inheritance. This is the chapter that matters most to many of you watching. You've worked your entire life to build wealth. You want to take care of your new spouse, that's only fair and right. But you also want to make absolutely certain that your biological children ultimately inherit your assets, not your spouse's children from their previous marriage. The challenge is creating a structure that provides for your spouse during their lifetime while guaranteeing that whatever remains goes to your children after your spouse dies. This is called providing for a life estate or life interest for your spouse, with a remainder interest for your children. There are several legal structures that can accomplish this, and which one is right for you depends on your specific situation, asset types, jurisdiction, and family dynamics. Let's go through each one, starting with the simplest and moving to the more sophisticated. Option 1. Life estate deed for real property. If your primary asset is your home and you want your spouse to live there until they die, but then have it go to your children, a life estate deed can work. Here's how it functions. You deed the house to your children, but reserve a life estate for yourself and your spouse. This means you and your spouse have the right to live in the home for as long as either of you are alive. Upon the death of the surviving spouse, the house automatically passes to your children without going through probate. The advantages: it's simple, inexpensive to set up, and your children are guaranteed to inherit the house. Your spouse has security of knowing they can live there for life. The disadvantages: your spouse cannot sell the house without your children's consent, since your children technically own the remainder interest. If your spouse needs to move to assisted living and wants to sell the house to pay for care, they'll need your children to agree and sign off on the sale. This can create conflict if your children refuse. Additionally, there are tax implications. In the United States, your children inherit the house at its value on the date of the first spouse's death, not the date of the second spouse's death. This might result in capital gains tax issues if the house appreciates significantly between the first and second deaths. Life estate deeds are common in the United States, available in most states. The United Kingdom has a similar concept called a life interest trust for property. Canada and Australia use similar mechanisms through provincial and state property laws respectively. This strategy works best when the house is your primary asset, your spouse doesn't need the flexibility to sell it, your children are trustworthy and get along with your spouse, and you want simplicity. Option 2. Qualified Terminable Interest Property QTIP Trust. Now we're moving into more sophisticated territory. A QTIP trust is specifically designed for second marriages and is one of the most powerful tools for balancing spouse and children's interests. Here's how a QTIP trust works. You create a trust that holds your assets. Upon your death, your spouse receives all income generated by the trust for the rest of their life. They might also be able to access principal for health, education, maintenance, and support needs. But your spouse cannot change the ultimate beneficiaries. When your spouse dies, whatever remains in the trust goes to your children guaranteed. The key features that make QTIP trusts so effective: your spouse is taken care of financially for life through the trust income and limited principal access. Your children are absolutely protected because your spouse cannot disinherit them. The trust language locks in your children as the final beneficiaries. You maintain control from beyond the grave about how assets are used. In the United States, QTIP trusts have a huge additional benefit. They qualify for the unlimited marital deduction for estate tax purposes. This means assets passing to the QTIP trust are not subject to estate tax at the first spouse's death, but they are included in the surviving spouse's estate at their death. For wealthy families, this provides important estate tax planning flexibility. As of 2025, the federal estate tax exemption in the United States is $13.61 million per person. If your combined estates exceed this amount, QTIP trusts become especially important for tax planning. Many states also have their own estate or inheritance taxes with much lower thresholds. In the United Kingdom, the equivalent structure is called a life interest trust or interest in possession trust. It functions similarly: your spouse receives income for life, and the capital passes to your children at your spouse's death. The UK doesn't have estate tax in the same way the US does, but it has inheritance tax with a threshold of £325,000 as of 2025, with additional allowances for primary residences. In Canada, spousal trusts serve a similar function and can provide a tax deferral benefit. Assets can roll into the trust on a tax-deferred basis at the first spouse's death, with taxes eventually paid at the second spouse's death. Provincial laws vary on the details. In Australia, testamentary trusts created in your will can provide similar protection for second marriages. These trusts are created upon death and can be structured to give your spouse a life interest while preserving capital for your children. Critical consideration: who serves as trustee of your QTIP or similar trust? This person or institution will have significant power over distributions and must balance your spouse's needs against preserving assets for your children. Your options include your adult child from your previous marriage, but this can create conflict with your spouse; your new spouse themselves, but they might be too generous with distributions to themselves, depleting the trust; a corporate trustee like a bank or trust company, neutral but expensive; a trusted friend or advisor works if you have someone suitable. Many estate planners recommend a co-trustee approach. Your spouse serves as one trustee for their lifetime, giving them input on their own financial security, while an independent party serves as co-trustee to protect your children's remainder interest. The costs of a QTIP or similar trust: initial setup with an estate planning attorney typically ranges from $2,000 to $5,000 depending on complexity and location. Annual trust administration costs range from 0.5% to 1.5% of trust assets if using a corporate trustee, or lower if family members serve as trustees. QTIP trusts make the most sense when your estate exceeds $500,000, you have significant liquid assets like investments or retirement accounts that generate income. You want professional management of assets for your spouse. You're concerned about your spouse remarrying or being influenced by their children. You want to ensure your children definitely inherit something. But what if you want to give your spouse more than just income? What if you want them to have access to principal but still protect your children? That's where bypass trusts and other hybrid structures come in, which we'll cover next. Let me show you a comparison table of different protective structures. Bypass trusts are B-trust structures, ALIT irrevocable life insurance trusts, prenuptial agreement connections, guardian provisions for minor children from previous marriage, powers of attorney and healthcare directives in second marriages. Chapter 4: Trusts for Blended Families. We've covered QTIP trusts and life estates, which are the foundation of estate planning for second marriages. Now let's explore additional trust structures and how they work together to create comprehensive protection for blended families. The bypass trust, also called a credit shelter trust or B-trust. A bypass trust is designed primarily for estate tax savings in the United States, but it also serves an important function in second marriages even if you're below the estate tax threshold. Here's the mechanics. Upon your death, assets up to the federal estate tax exemption amount $13.61 million in 2025 go into a bypass trust. Your spouse is typically the beneficiary and can receive income from the trust and sometimes principal for health, education, maintenance, and support. Your children from your previous marriage are named as remainder beneficiaries. The critical benefit for second marriages: these assets in the bypass trust are not included in your spouse's estate when they die. This means your full estate tax exemption is preserved, and more importantly for our purposes, these assets are guaranteed to go to your children, not to your spouse's children or a new spouse if your surviving spouse remarries. Many estate plans for second marriages use what's called an A/B trust or a B/C trust structure. Here's how this works. Trust A, Survivor's Trust. The Survivor's Trust holds assets that qualify for the marital deduction. Your surviving spouse has full control over these assets. These assets will be included in your spouse's estate at their death, and your spouse can change the beneficiaries if they choose. Trust B, Bypass Trust. Trust B holds assets up to your estate tax exemption. Your spouse gets benefits from the trust but cannot change the ultimate beneficiaries, your children. Trust C, QTIP Trust. Some plans add Trust C, a QTIP trust holding additional assets that qualify for the marital deduction, but where you want to control the final beneficiaries, not your spouse. Let's use real numbers. Say your estate is worth $1 million at your death. Trust B bypass could be funded with $2 million. Your spouse receives income and potentially some principal access, but at their death, this $2 million plus growth goes to your children automatically. Trust A survivors gets the remaining $2 million. Your spouse has full control, and this amount is included in their estate. They could leave it to your children, their children, a new spouse, or anyone they choose. This structure gives your spouse significant assets they control $2 million while guaranteeing your children receive at least $2 million plus growth from the bypass trust. The advantage of the A/B structure: it provides flexibility. If your relationship with your spouse is very strong and you trust them to take care of your children, more assets can go into Trust A, which they control. If you're more concerned about protecting your children's inheritance, more assets go into Trust B or Trust C QTIP, which lock in your children as beneficiaries. The Irrevocable Life Insurance Trust ALIT. Now let's talk about a structure specifically designed to remove life insurance from your taxable estate while providing for both your spouse and children: the Irrevocable Life Insurance Trust. An ALIT is a trust you create during your lifetime that owns a life insurance policy on your life. Because you don't personally own the policy, the trust does. The death benefit is not included in your taxable estate. For second marriages, ALITs solve several problems simultaneously. Problem 1. You want to provide your new spouse with liquid cash at your death to cover immediate expenses and maintain their lifestyle. Problem 2. You want to ensure your children receive an inheritance equal to or greater than what your spouse receives. Here's how an ALIT addresses both. Let's say you have $1 million in assets and you're leaving everything to your new spouse to provide for them. You're worried your children will get nothing if your spouse doesn't leave assets to them. Solution: you establish an ALIT and purchase a $1 million life insurance policy owned by the trust, with your children as beneficiaries. Now, when you die, your spouse inherits your $1 million in assets, providing for their financial security. And your children receive $1 million in life insurance from the ALIT. Everyone receives equal treatment, and your children's inheritance is guaranteed. The cost of this strategy depends on your age and health. A healthy 55-year-old might pay $8,000 to $12,000 annually in premiums for a $1 million policy. A 65-year-old might pay $18,000 to $25,000 annually. These are estimates. Actual costs vary based on underwriting. ILITs are primarily a United States estate planning tool because the US has an estate tax system where they're most beneficial. However, life insurance trusts can be used in the UK, Canada, and Australia for asset protection and beneficiary control purposes, even though the tax benefits differ. In the United Kingdom, placing life insurance in trust removes it from your estate for inheritance tax purposes. Given the UK's £325,000 inheritance tax threshold as of 2025, this can be valuable even for moderate estates. The trust ensures the death benefit goes to your chosen beneficiaries, your children, rather than passing under your will to your spouse, who might ultimately leave it to their own children. In Canada, life insurance death benefits are generally not subject to income tax, but insurance trusts can still be useful for directing benefits to specific beneficiaries and protecting assets from creditors. Provincial laws vary on the creditor protection aspects. Australia has insurance bonds, which are investment products that can serve similar estate planning functions, though they're structured differently than US life insurance policies. Dynasty trusts and generation skipping. For families with significant wealth, dynasty trusts can protect assets for multiple generations while providing for a second spouse in the interim. A dynasty trust is designed to last for multiple generations, potentially forever in some states that have abolished the rule against perpetuities. This type of trust can provide for your current spouse during their lifetime, then for your children during their lifetimes, then for your grandchildren, and so on. Dynasty trusts make sense when your estate exceeds $5 to $10 million. You want to protect assets from your children's potential creditors or divorces. You have concerns about your children's money management skills. You want to create a lasting legacy for multiple generations. In the United States, there's a generation skipping transfer GST tax that applies when assets skip a generation, going from grandparent directly to grandchild, bypassing the parent generation. As of 2025, the GST exemption is the same as the estate tax exemption, $13.61 million per person. Proper structuring of dynasty trusts can maximize the use of this exemption. Not all US states allow dynasty trusts. States like Delaware, South Dakota, Alaska, and Nevada have abolished the rule against perpetuities, allowing trusts to last indefinitely. If you live in a state that limits trust duration, your attorney might recommend establishing the trust under another state's laws. The United Kingdom has different perpetuity rules than the US. The Perpetuities and Accumulations Act 2009 sets a maximum trust duration of 125 years. This still allows for multi-generational planning, but not the forever trusts possible in some US states. Canada and Australia generally follow common law perpetuities rules with various statutory modifications by province and state. Multi-generational trusts are possible, but typically cannot last indefinitely. Special needs trusts for blended families. If you have a child with disabilities from your previous marriage, special needs planning becomes critical in your second marriage estate plan. A special needs trust, also called a supplemental needs trust, allows you to leave assets to benefit your disabled child without disqualifying them from government benefits like Medicaid, Medicare, Social Security, disability in the US, or similar programs in other countries. The challenge in second marriages. You want to ensure your disabled child is provided for after you die, but you also want to provide for your new spouse. A properly structured plan might include a special needs trust funded at your death for your disabled child, ensuring their care regardless of what your spouse does with other assets. An ILIT providing life insurance specifically for the disabled child's trust. A QTIP or other trust providing for your spouse while preserving some assets for your other non-disabled children. Special needs planning requires coordination between your estate attorney, a special needs trust specialist, financial advisors, and potentially government benefit specialists. The rules are complex and mistakes can be devastating. In the United States, different types of special needs trusts have different rules. A first-party special needs trust funded with the disabled person's own assets requires Medicaid payback at death. A third-party special needs trust funded by parents or others does not require Medicaid payback and can ultimately benefit other family members. The United Kingdom has similar trusts called disabled persons trusts with inheritance tax advantages. Canada and Australia have trust structures for disabled beneficiaries with various provincial, state rules and benefit coordination considerations. Continue with trust protectors and trust committees, modification and accounting of trusts, domestic asset protection trusts, digital assets in estate planning, trust administration after death. Chapter 5. Beneficiary designations, the most critical piece. This chapter could be the most important 7 minutes you watch in this entire video. I'm going to show you how accounts worth hundreds of thousands or even millions of dollars can completely bypass your carefully created trust-based estate plan and go to the wrong people, simply because of outdated beneficiary designation forms. Here's the fundamental principle you must understand. Beneficiary designations on retirement accounts, life insurance, and certain other financial accounts override your will and bypass your trust. It doesn't matter what your will says, it doesn't matter what your trust says. The beneficiary form controls these assets. Let's identify which assets are controlled by beneficiary designations. Retirement accounts, 401k plans, 403b plans, traditional IRAs, Roth IRAs, SEP IRAs, simple IRAs, pension plans, defined benefit plans, life insurance, term life insurance, whole life insurance, universal life insurance, variable life insurance, group life insurance through your employer, annuities, fixed annuities, variable annuities, immediate annuities, deferred annuities, transfer on death TOD accounts, brokerage accounts with TOD designations, bank accounts with payable on death POD designations, real estate with transfer on death deeds in states that allow them, vehicles with transfer on death titles in states that allow them. Now add up how much you have in these types of accounts. For many people, retirement accounts and life insurance represent 50% to 80% of their total estate. This means the majority of your wealth is controlled by beneficiary forms, not by your will or trust. Here's where second marriages create unique problems with beneficiary designations. Federal law in the United States, specifically, ERISA rules governing 401k plans and pensions requires that your current spouse be the primary beneficiary of your retirement accounts unless they sign a written waiver. This means if you want to name your children from your previous marriage as beneficiaries of your 401k, your current spouse must formally give up their rights by signing a spousal consent form, typically notarized and witnessed. However, IRAs are not governed by ERISA. State law controls IRA beneficiary designations. In most states, you can name anyone you want as IRA beneficiary without spousal consent. But some community property states may give your spouse rights to IRA assets even without them being named as beneficiary. Imagine this scenario. You've been married to your second spouse for 5 years. You have $800,000 in your 401k and want your 2 adult children from your first marriage to inherit it. Your current spouse refuses to sign the spousal waiver. You're stuck. Your 401k must go to your spouse by federal law. What can you do? Several strategies. Strategy 1. Negotiate a trade-off. Offer your spouse other assets of equal value in exchange for signing the waiver. For example, you'll leave your spouse the house, which they can inherit through your will or trust in exchange for them signing the waiver allowing your children to inherit your 401k. Strategy 2. Roll your 401k to an IRA. When you leave your employer or retire, roll the 401k into an IRA. IRAs generally don't require spousal consent for beneficiary designations in most states. But check your state law. Some community property states might still give your spouse rights. Strategy 3. Purchase life insurance for your children. Keep your current spouse as your 401k beneficiary since they won't sign the waiver, but purchase life insurance equal to the 401k value and name your children as beneficiaries of the insurance through an ALIT. Life insurance has more flexibility. You can generally name anyone as beneficiary without spousal consent. This makes life insurance an excellent tool for second marriages when you want to provide an inheritance to your children that your spouse cannot change. Should you name your trust as beneficiary of retirement accounts and life insurance instead of naming individuals? This is a complex question with tax implications. For retirement accounts, 401k, IRA, naming your trust as beneficiary is usually a bad idea from a tax perspective. Here's why. When individuals inherit retirement accounts, they can stretch the distributions over their life expectancy, minimizing income tax impact. The Secure Act of 2019 changed this to a 10-year distribution period for most non-spouse beneficiaries, but it's still better than the alternative. When a trust inherits a retirement account, the required distributions often must be taken much faster, sometimes within 5 years, and the income is taxed at trust tax rates, which are much higher than individual rates. Trust tax rates reach the maximum federal rate of 37% at just $14,450 of income as of 2025, compared to $609,350 for a married couple filing jointly. There's an exception: see-through trusts, also called conduit trusts, that meet specific IRS requirements can allow stretch distributions and avoid the harsh trust tax rates. These are complex to draft and must meet 5 precise criteria. Naming a trust as retirement account beneficiary makes sense when your children are minors and cannot manage an inheritance. Your children have creditor problems or are in high-risk professions. Your children have substance abuse or gambling problems. You want to ensure assets eventually go to grandchildren after your children's generation. For life insurance, naming your trust, or better yet, an ILIT as beneficiary is often a good strategy. Life insurance death benefits are income tax-free, so you don't have the tax concerns that apply to retirement accounts. The trust can then distribute the insurance proceeds according to your detailed instructions. Always name contingent backup beneficiaries on every account. Here's what happens if you don't. You name your new spouse as primary beneficiary on your $600,000 IRA. No contingent beneficiary listed. You and your spouse die together in an accident. Your IRA now passes according to the IRA contract default provisions, which typically means it goes to your estate. Your estate must distribute it according to your will, but your will leaves everything to your spouse who's deceased, so it goes to intestacy. Your children might end up sharing the IRA with your spouse's children, which is not what you wanted. Proper beneficiary designation: primary beneficiary, your spouse if required by law or desired. Contingent beneficiary, your children from your previous marriage in equal shares. Or if using a trust, primary beneficiary, your spouse. Contingent beneficiary, your trust, which has detailed instructions for distributing to your children. When must you review beneficiary designations? At these life events: upon remarriage, upon divorce, birth or adoption of children, death of a beneficiary, significant change in assets, large inheritance, business sale, etc., every 3 to 5 years even if no life event occurred. Here's your action checklist for this week. Step 1. Make a list of every financial account you own. Check old statements if needed. Step 2. Contact each financial institution, bank, brokerage, 401k administrator, IRA custodian, insurance company and request a current beneficiary designation form for each account. Step 3. Compare what's listed to what you want. Make note of accounts where beneficiaries are wrong, outdated, or missing. Step 4. Decide on your beneficiary strategy based on what you've learned in this video. Consult with your estate planning attorney if you have one, or plan to hire one if you don't. Step 5. Complete new beneficiary forms for every account that needs updating. Don't just plan to do it, actually fill out the forms and submit them. Step 6. Keep copies of all beneficiary forms in your estate planning file. Tell your executor or trustee where these copies are located. Step 7. Set a calendar reminder for 3 years from now to review all beneficiaries again. Common beneficiary designation mistakes that destroy estate plans for second marriages. Mistake 1. Naming your estate as beneficiary forces probate, loses tax benefits, can create unintended distributions. Mistake 2. Naming only your new spouse with no contingent beneficiary risks, assets going wrong place if spouse dies before or with you. Mistake 3. Naming minor children directly forces court-supervised guardianship of funds, expensive and inflexible. Mistake 4. Using per capita instead of per stirps for multiple beneficiaries changes who inherits if a child predeceases you. Mistake 5. Forgetting to update after divorce from previous spouse. Ex-spouse may inherit even though you didn't intend it. Mistake 6. Not coordinating beneficiaries with your overall estate plan beneficiaries that contradict your trust's intentions. If your estate includes significant retirement accounts, say $500,000 or more, or if you have complicated family situations, do not try to handle beneficiary planning yourself. The tax rules are complex, and mistakes can cost your family tens or even hundreds of thousands in unnecessary taxes. Spend the $2,000 to $5,000 for proper estate planning advice. It's the best money you'll ever spend. Chapter 6. Life Insurance Strategies. Life insurance is one of the most powerful and flexible tools for estate planning in second marriages. Unlike retirement accounts, which have complex tax rules, or real estate which can't be easily divided, life insurance provides immediate, liquid, tax-free cash exactly when your family needs it most. Here's why life insurance is so effective for second marriages. It creates new wealth that didn't exist before, allowing you to provide for both your spouse and your children without anyone feeling shortchanged. It provides immediate liquidity at death, no waiting for probate, no selling assets, just cash within days or weeks. Death benefits are income tax-free to beneficiaries in the US, UK, Canada, and Australia. You control the beneficiaries through the policy designation, which generally cannot be changed by your spouse after your death. Life Insurance Strategy 1. Creating equal inheritances. This is the scenario I mentioned earlier. You have $800,000 in assets. You want to leave everything to your new spouse so they're financially secure. But you also want your children to inherit something equal. Solution. Purchase an $800,000 life insurance policy and name your children as beneficiaries, ideally through an ILIT as we discussed. Your spouse inherits your $800,000 in assets. Your children receive $800,000 in life insurance. Everyone receives equal treatment. Family harmony is preserved. What's this cost? For a healthy 55-year-old, an $800,000 20-year term life insurance policy might cost $2,000 to $3,000 annually. For a 60-year-old, maybe $3,500 to $5,000 annually. For a 65-year-old, $6,000 to $9,000 annually. These are rough estimates. Actual costs depend on your health, gender, smoking status, and the insurance company. Should you buy term or permanent life insurance? Term insurance is cheaper but only lasts for a specified term 10, 20, or 30 years. If you outlive the term, you receive nothing. Permanent insurance, whole life, universal life, or variable life lasts your entire life and builds cash value, but costs 5 to 10 times more than term insurance. Use term insurance when you need coverage for a specific period until your children are financially independent, until certain debts are paid off, until your spouse has other income sources. You want maximum coverage for minimum cost. Your need is temporary. Use permanent insurance when you have a permanent need: estate tax planning, guaranteed inheritance for children. You have high net worth and can afford the higher premiums. You want the forced savings aspect of cash value accumulation. Life insurance strategy 2. Equalizing illiquid assets. Your main asset is a $1.5 million family business. You want your daughter from your first marriage to inherit and run the business. Your spouse has no interest in the business. Your two stepchildren from your current spouse's previous marriage aren't involved in the business either. Problem: if your daughter inherits the business, your spouse and stepchildren might feel treated unfairly. The business represents most of your wealth. Solution: purchase life insurance equal to or greater than the business value. Your daughter inherits the business. Your spouse and potentially your stepchildren inherit life insurance proceeds. Everyone receives fair value. For business owners, split-dollar life insurance arrangements can allow the business to help pay premiums, potentially making larger policies more affordable. This is complex and requires specialized professional advice. Life insurance strategy 3. Replacing assets diverted to spouse care. You're planning to leave $600,000 to your 3 children from your first marriage. But you're worried. What if your second spouse develops dementia or needs years of nursing home care, spending down all your assets? If your spouse needs 5 years of nursing home care at $100,000 per year realistic costs in many US locations as of 2025, that's $500,000 of your estate gone for their care. Your children's inheritance is wiped out. Solution: purchase $600,000 of life insurance on your life, with your children as irrevocable beneficiaries. Regardless of what happens to your other assets, even if everything is spent on your spouse's care, your children are guaranteed to receive $600,000 in life insurance. Second to die life insurance survivorship life. There's a special type of life insurance called second to die or survivorship life that insures to people you and your spouse, but only pays a death benefit when the second person dies. Second to die policies are significantly cheaper than insuring one person because the insurance company doesn't pay out until both of you have died. This type of policy makes sense when you're using the policy primarily for estate tax planning, since estate tax is typically due at the second death. You want to guarantee your children and your spouse's children all receive equal inheritances after both spouses have died. You have significant age or health differences between spouses, making individual policies expensive. A second to die policy on a 60-year-old couple might cost 30% to 50% less than 2 individual policies with the same total death benefit. Continue with policy ownership strategies. Absolute assignment versus collateral assignment, life insurance in divorce situations, long-term care riders, chronic illness riders, premium financing for high net worth individuals. Chapter 7. Action steps and critical warnings. We've covered an enormous amount of information in the past 45 minutes. Estate planning for second marriages is complex, with legal, tax, and family dynamics all intertwined. But don't let the complexity paralyze you into inaction. Taking no action is the worst possible choice. Here's what you must do within the next 7 days. Action 1. Review all beneficiary designations on every financial account. I gave you the detailed checklist in Chapter 5. Do this before the end of this week. This single action could save your family hundreds of thousands of dollars and years of conflict. Action 2. If you don't have a current estate plan, or if your estate plan was created before your current marriage, schedule a consultation with an estate planning attorney this month. Not next year, not someday, this month. How to find an estate planning attorney. State bar associations have referral services. Ask your financial advisor or accountant for recommendations. Look for attorneys who specialize in estate planning or trusts and estates, not general practice attorneys. Many offer free initial consultations. Bring these questions to your attorney consultation. How do we protect my children's inheritance while providing for my spouse? What type of trust structure do you recommend for our situation? Should we use a QTIP trust, bypass trust, or other structure? How do we handle beneficiary designations on retirement accounts? Do we need life insurance as part of our plan? What are the costs for creating this estate plan? Action 3. Have an honest conversation with your spouse about estate planning goals. This is uncomfortable but necessary. Discuss. How do we want to treat all our children, yours, mine, and potentially ours together? What does fair mean in our situation? Is it equal dollar amounts or something else? What level of financial security does the surviving spouse need? Are we willing to sign prenuptial or postnuptial agreements if needed? Action 4. Gather documentation of all assets and liabilities. Create a comprehensive list: real estate, home, vacation property, investment property, retirement accounts, 401k, IRAs, pensions, investment accounts, brokerage, mutual funds, bank accounts, life insurance policies with face amounts, business interests, debts and obligations. Your attorney will need this information to create an effective plan. Critical warnings. Do not make these mistakes. Warning 1. Do not use online estate planning services or software for second marriage situations. The complexity requires personalized professional advice. A $300 online template will not protect your family adequately. Warning 2. Do not delay because you don't want to think about death or you think you're too young. Death and disability can happen at any age. The best time to plan is now, while you have mental capacity and can make thoughtful decisions. Warning 3. Do not keep your estate plan secret from your adult children. While you don't need to share every detail, your children should know the general structure of your plan and understand that you've taken steps to be fair to everyone. Surprises after death create litigation. Warning 4. Do not assume your spouse will do the right thing and take care of your children after you're gone. Even with the best intentions, life circumstances change. Legal structures are more reliable than verbal promises. Warning 5. Do not create an estate plan and then never review it again. Life changes, laws change. Your plan should be reviewed every 3 to 5 years or whenever major life events occur. Continue with cost expectations for estate planning. What to expect in the estate planning process. Timeline from initial consultation to completed documents, ongoing maintenance and updates. Conclusion and next steps. Let's recap the critical points from this masterclass. Second marriages create unique estate planning challenges because you have competing goals, providing for your new spouse while protecting your children's inheritance. Your old estate plan likely became invalid when you remarried, and even if it didn't, it probably doesn't address these unique challenges. Simple wills don't work for second marriages. You need specialized trust structures like QTIP trusts, bypass trusts, or life interest trusts depending on your jurisdiction. Beneficiary designations on retirement accounts and life insurance override your will and trust. These must be coordinated with your overall estate plan or they'll destroy your carefully laid plans. Life insurance is one of the most flexible and powerful tools for second marriages, allowing you to create new wealth to provide for everyone fairly. This is not a do-it-yourself situation. Work with qualified professionals, an estate planning attorney licensed in your state or province, a financial advisor who understands estate planning, a tax professional for tax implications, and an insurance specialist if using life insurance strategies. Ultimately, estate planning for second marriages is about more than money and taxes. It's about preserving family harmony, showing love and fairness to everyone you care about, and ensuring your life's work benefits the people you want to support. Your action step this week: review your beneficiary designations and schedule an appointment with an estate planning attorney. Don't wait. If this video helped you, subscribe to Midlife Money Method for more in-depth financial planning guides. Our next video covers prenuptial agreements for second marriages and how they coordinate with estate planning. Final reminder: this video is educational content only and does not constitute legal advice. Estate planning laws vary by jurisdiction and change frequently. Consult licensed professionals in your area for advice specific to your situation. Thank you for watching. Protect your family. Plan properly, and I'll see you in the next video.